Good morning. This is Chris Denicolo here to talk to you today on our Saturday webinar series. I apologize for those of you who expected to see Alan today. Unfortunately, Alan is out for the day, and I am filling in for him. So for those of you who rushed around to get here on time in hopes of seeing Alan and his wonderful ventriloquism skills, my condolences to you. I will hopefully try to do a job worthy of at least the dummy that he presents with from time to time. And today we're going to talk about something that I like to call alphabet soup, which really is just a basic estate planning survey of the various techniques that we commonly use, which of course are commonly termed by use of acronyms. Things like LLCs and IDGTs and GRATs and CUPERTs, CLATs and CRUTs and SLATs and so forth. And a lot of people may not know what those terms actually mean, and my goal today is to hopefully demystify some of the esoteric and complex techniques by boiling them down into a real simple fashion and discussing when they can be useful, how they work, and what they can do to help your clients have better estate plans and tax plans. So without further ado, I'm going to jump into our normal housekeeping that we typically provide in these seminars. First, this presentation does not qualify for continuing education credit, unfortunately, but we can send you these PowerPoint slides at any point if you would like. They should be available in the handout section of the GoToWebinar side panel. And then, of course, within 3 to 5 hours after the webinar, all attendees are going to receive a follow-up email with a recording and PowerPoint materials so that if you ever have trouble sleeping at nighttime, you can just play this back and fall back to dreamland without much ado. Also want to talk about how to ask questions here. For those of you who are new to the GoToMyWebinar system or GoToMyMeeting system, you can click the red arrow at the top and type in a question, and I'll do my best to answer the question as best as possible. Hopefully, a lot of the questions will come up organically throughout the presentation. Previewing future presentations, this coming Monday, there is a presentation, a live presentation in Fort Myers that Wesley Dixon, myself, and James Constable of the Constable Law Firm will be giving regarding navigating denied insurance claims and getting insurance coverage for damage that may have been caused by the hurricane. And I'll also be talking about estate planning and asset protection updates, which, as you know, are very important. And certainly when things like a hurricane come through, it reminds us of whether we have all of our boxes checked, all of our T's crossed and I's dotted. Estate planning it's never a bad time to consider whether a sound estate plan is in place for either yourself or your clients. And of course, we have our library of webinars throughout the years here. Many of you have tuned in on past Saturdays where we've given talks on a variety of topics. We also have talks from years ago, from before the normal Saturday webinars were given, when we used to do something called Learn at Lunch or Lunch and Learn. In any event, we have a really robust section of presentations available on the YouTube library. So I encourage you to check that out if you are interested in learning more about tax and estate planning topics, or again, if you have trouble sleeping and need the dulcet tones of Alan's voice or my voice to help you get back to dreamland. All right, so now we're jumping into the substance of our presentation. And just starting at the most fundamental level, I think it's important to understand the basic estate planning definitions and terms that pop up when working on a client's estate plan. One of the most fundamental terms is probate. And the way probate is portrayed in literature and I want to say in the media to some extent is that it's this big, bad, evil thing that you want to avoid at all costs. Well, what probate really means, it's a court process whereby a deceased person's individual assets are marshaled, the deceased person's will is deposited, creditors are paid, tax requirements are satisfied, and distributions are made in accordance with the decedent's will. It does involve court intervention, which is why you see a lot of literature out there asking or suggesting to avoid the probate process. This is completely apart from estate tax and inheritance taxes, and it is a state law process that is used to help marshal a decedent's assets and assure that they are paid out in accordance with the law and the decedent's documents. Of course, one of the biggest things that we do as estate planning lawyers is try to avoid probate. And by doing so, we use vehicles like beneficiary designations and revocable trusts, because with those types of vehicles, assets can pass to intended beneficiaries without the need for court intervention. And it's not that court intervention in and of itself is problematic, it's just that it takes a long time. It takes a lot longer than some clients are accustomed to if they'd rather have their beneficiaries access funds on a more frequent basis. They can use a living trust to avoid that probate process. Additionally, there are privacy issues that come up because just about everything in a probate file is available for public record. And most clients that we talk to do not want to have their wills and their disposition documents really available to the public to the extent that they reveal confidential information. Most of the wills that we prepare for clients are what's called pour-over wills. And what that means is that all of the assets, or virtually all of the assets, owned in the individual name of the decedent are pouring into the living trust. So the will, if a curious third party wants to find out what John Smith's will says, and he goes to court and pulls the will would say something like, all of my assets are to pass to the John Smith Revocable Trust, dated November 5th, 2022, in which event there's really nothing to indicate what John Smith wanted to do with his assets, and the trust, meanwhile, can provide for complex distributions and a variety of dispositions that maybe John Smith wants to keep within a close circle. Another concept to understand is that of personal representative. Now, the personal representative is referred to in different states as the executor or the executrix. Those generally mean the same thing from a state law probate standpoint. In Florida, we use the term personal representative, so that's why you sometimes see that we make that reference as opposed to executor. We also have this concept where the personal representative is responsible for marshaling the assets of the decedent, paying creditor claims, assuring that tax filings are done, including an estate tax return, and we'll get into tax planning here in a minute, but the personal representative can be a job that is quite substantial. And we always tell clients, you want to make sure that you choose choose a person who is not only aware of your wishes as personal representative, but also is prudent with money, is able to handle deadlines and handle marshaling assets and assuring that certain things are accomplished. I'm going to skip to the next slide now and kind of touch on what we mentioned earlier, the revocable trust, which is one mechanism that's used to pass outside of probate. Now, in going with our theme today, our alphabet soup theme, a revocable trust sometimes is referred to as an RLT, or revocable living trust. It's sometimes also referred to as a living trust. Those terms are generally interchangeable, and it's essentially a trust vehicle that the grantor can control, can revoke, amend, modify, essentially deal with that trust as if it were the person himself or herself. The sole purpose for most living trusts is to avoid the probate proceeding and to provide for disposition of assets in a manner that's not necessarily available to public. The trust document contains provisions that cause beneficiaries to have interest in the trust and legal rights in the assets held by the trust. Those interests held by the beneficiaries can vary significantly depending on the kind of trust. And we'll get into these varieties of trusts as we tick down the line here on this presentation. I do want to point out, in a revocable trust, because it is revocable by the settlor or grantor, the beneficiary's rights generally are not fixed or vested until the settlor's death. So a very interesting concept to understand, very commonplace in a lot of the planning that we do. Conversely, we have an irrevocable trust, which is, as it says, generally irrevocable, meaning that the settlor or the grantor cannot change the trust in any fashion. Now, the revocable trust, a lot of times, most of the time I should say, becomes irrevocable on the settlor's death. That is usually what happens with revocable trusts. Nevertheless, there are irrevocable trusts that can be established during lifetime by a grantor to hold assets, and those trusts can be irrevocable as to the settlor, meaning that the settlor cannot change what goes under the trust. One of the most common reasons for doing so is to have an irrevocable trust own assets that would be outside of the grantor's estate for federal estate tax purposes. That said, irrevocable trusts are very common in the context of avoiding estate taxes. And a lot of what we'll talk about today are varieties of irrevocable trusts that can be used to avoid federal estate tax. Certain acronyms that some of you may have heard before are ILITs, which stands for Irrevocable Life Insurance Trust, and that's nothing more than an irrevocable trust that owns a life insurance policy. Another term that I will be using later is an IDGT, an IDGT, and what that stands for is Intentionally Defective Grantor Trust. That type of trust is simply an irrevocable trust that is considered as owned by the grantor for federal income tax purposes. It may not necessarily be owned by the grantor for estate tax purposes, but would be considered for income tax purposes. And let me give you an example of how that works. For an IDGT, you may have a trust that I set up for my spouse, which provides that my wife Sophia can receive distributions as determined for health, education, maintenance, and support. And Sophia can be the trustee of the trust. The trust also provides that my children can receive distributions from the trust. The fact that my wife is the trustee of the trust generally causes it to be considered as owned by me for federal income tax purposes. What that means is that I will pay income taxes associated with all of the trust's activities, even though the trust would be outside of my estate for federal estate tax purposes, and I have absolutely no authority or ability to reach into the trust and benefit from the trust assets. You may think, well, why the heck would anyone do that? Why would they give away assets but still be taxed on the income that relates to those assets? Well, there are a number of estate tax planning techniques that we will get into that are essentially prefaced on that very loophole, if you want to call it, in the tax code, because transactions that I engage with that IDGT are not considered to be taxable transactions for federal income tax purposes. For example, if I sell assets to that trust, those assets may be appreciated. Nevertheless, I do not recognize income tax on the sale because under an Internal Revenue Code revenue ruling from 1985, it's like my right hand sold it to my left hand. It's essentially a transaction between me and myself. Even though my wife and my children are the beneficiaries, that particular area of the law, or I guess phenomenon in the law, allows for a really nice way to pass wealth outside of one's gross estate. And we'll get into that here in a minute. A few other items that are not necessarily germane to, planning for estate tax planning and using the quote unquote alphabet soup acronyms that are available to us, nevertheless are important. A living will, a healthcare power of attorney, a durable power of attorney are very much useful and are encouraged to be in place for an individual to ensure a proper estate plan. And what these documents generally do is apply during a person's lifetime to help assure that they have individuals named who will serve as the persons that can make healthcare decisions and financial decisions on the individual's behalf, if something were to happen to the person in question. So, my power of attorney, I appoint my wife Sophia to make decisions for me in the event that I am not able to do so. Likewise, a living will, something similar to that, but essentially provides a person's wishes to as to whether they want to be artificially kept alive or if they want to have life support withdrawn for if they're in a permanent vegetative state with no reasonable likelihood of recovery, something to that effect. So I'm going to skip us ahead to the estate tax basis so we can start to drill down on some of the available techniques that can be useful in avoiding estate tax. So simply put, a federal estate tax is imposed upon citizens and permanent residents of the United States if the person's assets exceed what's called as an estate tax exemption. And that exemption number currently in 2022 is $12,060,000 minus any taxable gifts that were made during lifetime by that person. So think of it this way, that exemption is a reservoir that a person can tap into during their lifetime to shield assets from gift tax and from estate tax upon their death by using this credit or this exemption to offset the amount of gifts that are made. Now, the $12,060,000 amount is really high. In fact, 99.9% of families in the United States will not have an estate tax problem because that number is so high. But for context purposes, about 20 years ago, that number was as low as $600,000. And as recent as 2016, that number was about $5,500,000. What's more is that exemption level is scheduled to decrease to approximately $7 million come 2026. Now, the old adage, of course, is that the law is permanent, meaning that it is the way it is until Congress and the president change it again. It remains to be seen whether that $7 million, the reduction to $7 million will continue to apply, or if it will be reduced further down, or if it will be increased and the 12 million plus inflation amounts will be here to stay. I will also mention that last year, the president floated a potential act called the Build Back Better Act, which did not become law. And in that act, the objective was to reduce the exemption down to $3,500,000 per person. So that number is a moving target. And I tell a lot of clients that my crystal ball doesn't work all that well. So I almost never can tell when a client is going to die and what the estate tax law is going to be in the client's year of death. As a result, for many clients who may not be near this $12 million number, you may want to encourage estate tax planning to get ahead of a situation where either the client's assets increase up to a certain level so that they're flirting with crossing this threshold, or where the exemption is ratcheted down in the future to a level where it would be below what the client's assets might be expected. So that's a very important concept to understand. And some of the planning we'll talk about today involves using that exemption amount while it's still available before it goes down to 7 million approximately in 2026. I also want to mention the $16,000 per year annual gift tax exclusion amount. And this is a neat gifting advantage that occurs in addition to the exemption. As a general rule, a US citizen or permanent resident can give $16,000 per year to each person, that whoever they want, without reducing that reservoir of $12,060,000 of lifetime gifting exclusion. Giving you an example here. If I give my sister $16,000 in cash, then that does not reduce my $12 million exclusion. However, if I give her $116,000 in cash, then what has happened is my $16,000 annual exclusion amount is used as to her, and my roughly $12 million exemption amount is reduced by an additional $100,000. But this annual exclusion technique is very helpful to help pass wealth outside of a grantor's or a person's estate. So in calculating the estate tax return kind of goes through a calculation which we've summarized here. And the gross estate is generally the value of the assets of an individual, less deductions, plus any taxable gifts that they may have made in the past that get pulled back in for one reason or another, and multiplied by the estate tax rate to generally get at what the estate tax would be, of course, after accounting for something called the unified credit amount. And the unified credit amount is just another way to calculate the exemption that I referred to earlier, the $12 million exemption. I've left out two really big deductions that apply in a lot of estate plans that we do for clients. The most common one is the marital deduction. And what the marital deduction does is it allows for assets which are left outright to a surviving spouse or to a certain type of trust for a surviving spouse to avoid estate tax on the first death because of a deduction equivalent in value to what goes to the spouse. Here's an example. Let's say that my gross estate is $20 million and my estate tax exclusion amount is $12 million. Let's just keep it at 12 million to make the math easy. If I say in my estate plan, the minimum amount necessary to avoid estate tax goes outright to my wife, Sophia, then what would happen is Sophia would receive a distribution or disposition of approximately $8 million, and that would qualify for the marital deduction, meaning that my taxable estate would then be reduced by the $8 million amount that goes to her. Another more common mechanism is something called a Q-tip trust, another one of those acronyms. And this one is not brought to us by our friends at Johnson & Johnson. This comes straight out of Internal Revenue Code section 2056. And what Q-tip stands for is Qualified Terminable Interest Property. A Q-tip trust provides that if a spouse has rights to all income, if a surviving spouse is the sole beneficiary of the trust, and if the surviving spouse has the power to make the assets in the trust productive, meaning that they can earn income for her life, then the assets that pass to that Q-tip trust can qualify for the marital deduction, which reduces the amount subject to estate tax. The Q-tip trust requires that an election be made on an estate tax return, so it is very important to make sure that a return is filed if a Q-tip trust is a fundamental part of the estate plan. Another deduction I want to mention, and we'll talk about this soon, is the charitable deduction. And generally, assets that go outright to charity or that go to a certain type of charitable trust that benefits charity can qualify for deduction against the estate tax in a similar vein as the marital deduction. So those two deductions are very popular, and they can be used to avoid estate tax, as well as avoiding potential estate taxes by use of lifetime estate plan. One other topic I want to mention is this concept of portability. Now, portability is the ability of a beneficiary to pass a decedent to pass unused amounts of the estate tax exemption to his or her spouse, so that way you don't really have to assure that the first dying spouse has assets that fill up his or her exemption. Here's an example. Let's go back to my fictional $20 million estate. Let's say that instead of leaving Sophia $8 million and having $12 million go into a trust for my children, or for Sophia and my children, what I've instead done is left my entire $20 million estate to Sophia. First off, that would not be a bad or a good idea because of the tax reasons I'm about to discuss. But in any event, what Sophia can then do is file an estate tax return for me to elect to port my $12 million exemption to her, meaning that whatever portion of my exemption I don't use, she can use it on her later death. Now, that's kind of a good safety net, but because portability doesn't grow with inflation like the estate tax exemption does, and possibly can be remarried if Sophia remarries down the road, it's usually not a good idea to rely on portability. Nevertheless, it's there as kind of a safeguard, and a lot of times what we do is have portability in place where maybe the first dying spouse assets don't come close to the exemption level, and there's some unused exemption that can pass to the surviving spouse in the off chance that the surviving spouse assets increase in value dramatically, or, as I discussed earlier, in the chance that the exemption amount gets ratcheted down significantly so that the surviving spouse would have an estate tax issue. So on slide 17 here, we kind of have a summary of what typically applies for an estate plan that we would structure. And what we would say is on the first dying spouse's revocable trust, the exemption amount passes to a family trust or a bypass trust that is outside of the estate tax system. The remaining assets go to that Q-tip trust. And what I mean here is that this trust benefits only the surviving spouse. It causes the surviving spouse to have distributions for income only and distributions of principal if needed for health, education, maintenance, while deferring any estate tax that would occur at this point until the survivor's death. Now, another acronym that comes up often is something called GST. And what that stands for is generation skipping transfer. And what we typically say is that the family trust, to the greatest extent possible, passes outside of the estate tax system because it is GST exempt, meaning that it is generation skipping tax exempt. And by doing that, it will not be subject to estate tax at the level of the first dying spouse or at the level of the second dying spouse and thereafter, so long as the assets stay in trust. The Q-tip trust generally is non-GST, meaning that it is subject to estate tax on the surviving spouse's death and possibly could be subject to estate tax on the children's deaths down the road. So just a couple of ways to structure an estate plan to maximize tax efficiency. You know, we have our slide here, 18, how to structure married couple assets between the couple. And you'll see, separate revocable trusts. Florida, another acronym we typically use is TBE, or tenants by the entireties, which is a fantastic creditor protection tool. And how this works is that spouses own assets as tenants by the entireties. Those assets during the lifetime of both of them are generally protected from the creditors of only one spouse. So if I get sued for a car accident that Sophia has nothing to do with, our tenants by the entireties assets are protected from my creditors. However, a joint creditor, so if she and I both co-sign on a bank loan and the bank sues us, that joint creditor can reach tenants by the entireties assets. It's a very common protection tool here in Florida. It also causes assets to pass immediately and automatically to the surviving spouse on the first dying spouse's death. And that is just the way that the law works for tenants by the entireties. It's a fundamental part of tenants by the entireties law. But for many reasons, tenants by the entireties here in Florida has a lot of efficacy and is commonly used. Now, we talked briefly earlier about using irrevocable trusts, and one of such trusts is a gifting trust, which is our warm and fuzzy way of saying it's a trust for spouses and other descendants that could receive assets during lifetime, and it can hold those assets free of creditor claims and potentially outside of the estate tax system. But another type of irrevocable trust that I wanted to highlight is yet another acronym, and that is the SLAT. And that is typically stands for Spousal Lifetime Access Trust or Spousal Limited Access Trust. And the secret sauce to a SLAT is really just, it's an irrevocable trust that benefits the other spouse and one or more other beneficiaries, children, charities, nieces, nephews, grandchildren, etc. The idea here is that this is a trust that, for example, I can fund for Sophia, where she can be the trustee, she can receive distributions or benefits from the trust as a primary beneficiary. And by setting up a trust in that manner, we have flexibility in using my exemption and getting assets out of my estate for estate tax purposes, while still allowing my wife to be able to reach those assets so that we're just not giving all of our assets away to children. And we'll get into SLATs a little bit later here on the presentation. And then finally, as an introductory matter, the LLC, this is a limited liability company. These are very common in estate planning and for asset protection. And we're going to get into some LLC considerations here in a second. But LLCs are used in just about any complex estate tax planning technique that we employ. And the reason is, if you show this example here, this LLC in the middle, this 3% that may be transferred to the gifting trust, if I put $1 million under the LLC and transfer that 3%, well, it's probably not going to be worth $30,000 or 3% of $1 million, because the 3% is a minority interest that doesn't allow the gifting trust to affect the management of the LLC or access the assets. So by transferring ownership in the LLC on a minority basis, a valuation discount of maybe 30% would apply here. If, for example, the $1 million I put in is real estate or securities or interest in some closely held company, and that discounting mechanism can allow for more efficient transfer of wealth using one or more of the estate tax planning techniques that we commonly see. And those techniques are generally summarized here. I've gone over a lot of these things here. I'm not going to read through the list, but I did want to highlight things like qualified personal residence trusts, or CUPRTs as they're called, or charitable lead annuity trusts, or CLATs, or charitable remainder trusts, sometimes known as CRUTs. And we'll get to those topics here in just a minute. So I'm going to skip down to LLCs we talked about. Here are 8 common LLC planning errors. I think these are very important to understand and look at if you have clients planning with LLCs, to make sure that LLCs are appropriately structured. And as I mentioned, using an LLC in a wealth transfer technique can be very beneficial. So we have here a client who has placed $3 million of investment assets under an LLC. And the client says, I want to gift 99% ownership in this LLC and make it a 99% non-voting ownership at that, to a trust for my wife and descendants, so to a SLAT. And by making this gift of a 99% interest, if you apply a valuation discount of somewhere around 1/3, then you can value that gift at $2 million, even though virtually $3 million of assets have been pushed out of the estate. And this trust, this SLAT, can be used for the benefit of the spouse and children, and the client can replace the trustee of the trust at any point in time, and maybe each spouse would have control over 1/2 of the assets in the trust, by being able to change the trusteeship as to 1/2 if and when there is a divorce at some point. These types of mechanisms are very flexible and are a very efficient way to transfer wealth. Taking it a step further, some clients would prefer to engage in something called an installment sale to a defective grantor trust. Now, this one's not necessarily referred to as an acronym, but it involves an LLC and also involves an IDGT, or that defective grantor trust that I mentioned earlier. And in this instance, we have our client put $9 million into an LLC in exchange for 100% ownership that is split into 1% voting, 99% non-voting. The client then sells the 99% interest to the trust after putting a gift of $600,000 in the trust. And the reason for that gift is to provide a seed capital to the trust so that the trust has an independent net worth of something like 10% of the sale price. As we talked about earlier, that 99% interest can be valued using a discount to come out of approximately $6 million promissory note that would be owed back to the client. Now, this slide admittedly is a few months old, and when we did this slide earlier in the summer, I believe, the interest rate that can be used is 1.73% per year. Well, unfortunately, this percentage needs to be increased now because the interest rates have gone up to near 4%. So this concept the same, the numbers are a little bit different. But the way that this works is that each year after the sale, the trust, the SLAT, owes the client interest based upon the interest rate, and let's assume it's 1.73%. And 5 years later, you now have interest payments that go to the client, and the assets have grown from 9 million to 13.5 million. And by doing that, we were able to push out at least $4.5 million of assets out of the gross estate of the client because we froze the value at $6 million. In fact, more than $4.5 million, more like $7.5 million, because of the discounting mechanism and also because of the growth in the assets under the LLC. I also want to mention that this does not take into account the fact that the client has to pay the income tax on the SLAT. And because the SLAT is a grantor trust for income tax purposes, there are no, the income tax is paid by the client, and there is no tax on the sale. But the client will have to pay the income taxes associated with the trust assets, and that is not considered to be a further gift. So that's a very important technique that can be used to drain a client's gross estate on purpose by having the client subsidize assets or subsidize the payment of taxes of the trust activities. So this installment sale to an IDGT is a very common technique. A lot of clients have entered into these transactions. It can be very useful because the assets under this trust would not be subject to estate tax so long as they remain in the trust because of the way that the trust is structured. I also want to get down to other alternatives that apply in potentially transferring assets out of a gross estate. So we talked about the installment notes here, and we have our October numbers. I regret to say that November numbers are even higher now for sales that occur in the month of November. But in October, it really depends upon how long the promissory note term is. If it's less than 3%, you use the short-term rate, which usually is less than the midterm or long-term rate, but because of the unique interest rate cycle that we're in now, it is almost on par with the long-term rate, which typically applies if the rate is higher than, or if the term is higher than 9 years. Another acronym we typically use here is the SKIN, which is a self-canceling installment note. And that self-canceling installment note is nothing more than an installment sale to a grantor trust based upon what we talked about just a few minutes ago, except that if the client, if the seller dies during the term of the promissory note, the installment obligation from the trust would disappear. It would cancel. And that self-canceling installment note can be used and has had to have efficacy from the IRS or with dealing with the IRS if certain conditions occur. And one of those conditions is that the interest rate must be increased to a point where it reflects a risk premium because of the possibility that the client might die during the 14-year term. Because remember, if the client dies during the term of the note, the obligation disappears. So you have to think, what would a purchaser, or excuse me, what would a seller do in an arm's length scenario if they were selling assets to a third party? Well, they would require a significant premium on the interest rate, and we use an actuarial software program known as Tiger Tables to help us calculate this interest rate. Here it was 7.96%, almost 8%. Another condition is that the term of the note cannot be longer than the life expectancy of the seller. You can't say, yeah, I'm 70 years old and I'm going to do a 45-year skin, because the IRS is going to look at that and say, no, this is not bona fide because the client has a virtually 100% chance of dying before the 45-year term would expire. And then another acronym we typically use are GRATs, our Grantor Retained Annuity Trust, which we'll get into here momentarily, but that's another payment sale, deferred payment structure where a client can transfer assets to a trust and receive payments back each year based upon a percentage of assets that go into the trust. A very useful technique that can help push wealth out of one's estate. So we have a little bit more on the installment sale here, and you'll see that on slides 38 through 40. These are prior slides that we've showed to our clients, the Flintstones, when we helped them with their estate plan. There was a concern that Fred was going to get crushed by a boulder or stomped on by a brontosaurus. So a skin might work for him, even though he was age 66. In their scenario, we had them split assets up, where any assets that were owned as tenants by the entireties, we would have Fred take his assets, sell it to a slat for Wilma in exchange for a promissory note based upon the similar LLC structure that we referred to earlier, whereas Wilma would fund the trust for descendants using a similar installment sale transaction, and we would give Wilma the power to replace assets under this trust with assets of equal value, and that's what causes the trust to be a grantor trust for federal income tax purposes, meaning that there would not be any income tax on the sale by Wilma to this descendants trust. And you may be thinking, well, Chris, why didn't the Flintstones just simply transfer their assets to slats for each other? And the reason for that is because of something known as the reciprocal trust doctrine. The reciprocal trust doctrine prevents one spouse from setting up a slat for the other spouse and vice versa, because the IRS would come in and look at this and say, this appears to be as if each of you set up a trust for yourself. We're going to uncross these slats, and the assets of each trust are going to be included in the grantor's estate. That is why we typically like to have one trust provide for descendants only, and the other trust provide for spouse and descendants. And then, of course, the 10 years later story here is that Fred and Wilma's assets that were worth 20 million at the outset of this technique now are worth 40. And what we've done is pass 99% of that value outside of their estates when we froze the values at the roughly $7 million each that they were owed at the beginning of this transaction. So installment sales to IDGTs are extremely helpful and a great way to structure a wealth transfer plan in a manner that can cause assets to pass outside of a gross estate while freezing values at a lower level. Now, here we have some slides on slats. I'm not going to dive into slats because, candidly, I can speak for hours on slats alone. It's a very nuanced topic, but at its core, as I mentioned, an irrevocable trust for the benefit of one spouse set up by the other. The trust can be exempt from creditors. It can be outside of the estate tax system. It can be held in a manner where descendants can benefit from it. The other spouse, the beneficiary spouse, can have the power to change the disposition of assets under the trust so that flexibility is present if certain beneficiaries under the trust need to be disinherited or potentially added by use of the power of appointment. All right, so just a quick primer on the Florida law changes to slats. So one of the big things that's happened this year in our state is this concept that if I set up a trust for Sophia, that's a slat, in Florida, I can't be a beneficiary of that trust because if I am, my creditors can reach into that trust and the assets of the trust are included in my estate for federal estate tax purposes. Well, come May of this year, Governor DeSantis executed a bill which changed the Florida statute, which said that if I leave assets in trust for the benefit of Sophia, and on Sophia's death, I can receive assets from that trust. In essence, I can be a beneficiary of that trust. Then under Florida state law, she is considered to be the settlor of that trust for my benefit, not me. You may think, wow, this is almost like a boomerang slat that can come back and benefit me in this example as the grantor spouse. But there are some concerns regarding this legislation, because if I am a beneficiary that has a remainder interest, and because Florida law has exception creditors, meaning that my beneficiaries, or excuse me, my creditors could reach into that trust if it's a child support or if it's an alimony claim. My creditors being able to certain creditors being able to reach into the trust could cause the assets to be included in my estate for federal estate tax purposes. So it's not entirely safe to rely on the Florida statute here in allowing a grantor spouse to later become a beneficiary of the trust. A safer alternative would be to go to a place like Nevada, Alaska, South Dakota, Delaware that has a domestic asset protection trust statute that would say instead, I could be a beneficiary of that trust that I set up for Sophia, and my creditors can't reach into that trust under the applicable state law. Even that's not 100% bulletproof, but it certainly allows for the ability to have assets held for the benefit of uh, the grantor spouse. A lot of times what we will do for clients is set up a SLAT in a place like Nevada or South Dakota, and we would provide that a committee of independent trust protectors can appoint any descendant of my mother, for example, to be a beneficiary of that trust, so long as my net worth is below a certain threshold. And by doing it that way, it's like a hybrid approach where these trust protectors would have to affirmatively appoint me as a beneficiary of the trust, and my net worth would have to be so low that it would be so independently significant for me to be added to the trust that there's a lot greater chance that my creditors won't be able to reach into that trust and that the assets of the trust won't be included in my estate for federal estate tax purposes. Okay, so now the cousin of the installment sale to a grantor trust is the GRAT, the Grantor Retained Annuity Trust. And very simply, this trust provides for a grantor to place assets into an irrevocable trust, and in exchange to receive payments back from the trust based upon a specified percentage amount. The payments have to be paid at least annually and are calculated based upon the value of the assets that go into the trust on day one, accounting for a time value of money factor using the Section 7520 rate that the IRS publishes every month, and actuarial tables, so that assets in the trust remaining after the grantor receives all of the payments back can be held for the benefit of the surviving spouse or descendants or whoever the client wants. Essentially, if the assets grow in excess of that hurdle rate, which is the Section 7520 rate, it's now 4% this month, I believe, then the growth in those assets above that amount can be held free of estate tax without using the exemption level that I discussed earlier. So it's a very important technique and is commonly used. I'm essentially just going over the nuts and bolts of it here. It is a creature of statute. The Internal Revenue Code provides for the creation of a GRAT, so the IRS does respect them so long as fundamental document and funding requirements are complied with. For example, once the GRAT is funded, it cannot be funded again with subsequent contributions. Additionally, the grantor cannot receive a promissory note for the GRAT in exchange for one of the payments being satisfied. So if I put $1 million into a GRAT and it says every year for 4 years I'm supposed to get $275,000 back, well, the trustee of the GRAT can't say, well, Chris, we're going to pay you a promissory note of $275,000 to satisfy the trust payment. It just doesn't work under the GRAT rules. And then, of course, you can't commute. You can't early terminate the GRAT term. So that 4-year GRAT term that I mentioned, you can't say, Chris, we're just going to pay you, the entire amount, the 4 payments of $275. You're going to get those right now, and we're going to terminate the GRAT. It doesn't work that way. The GRAT has to go for the duration of the full year. Now, the payments have to be made annually, but there's a 105-day buffer following the anniversary date of funding that can be used to cause to make the payments. And then, of course, you can increase the payments each year as long as the increase is not more than 20% over the prior year. So scrolling down here, this is one we did for a client. The client had a company that was throwing off $3 million in annual income, and the client took 10%, put it into the GRAT, and based on the actuarial factors, the GRAT payment was about $120,000 a year. Well, $300,000 of income, flowed out from the company to the GRAT, and then the GRAT paid $120,000 a year to the client. And by doing that, the GRAT was able to build up excess cash and reinvest that cash for the benefit of the desired beneficiaries. And you'll see here on the next slide how the math worked. $300,000 a year of income, less $120,000, and then the excess cash growing at 7.5%. At the end of the term, 10% of the company plus over $2.5 million were in the trust, and the client did not use any gifting exclusion when they did this. They funded it so that the present value of the payments back to them was equal to what they put into the trust, meaning that there was no reduction of the client's estate tax exemption. So a very useful tool here, and that type of GRAT is called a zeroed out GRAT. I have some more detail here for one we did several years ago. And what's more is we have slides on increasing the GRAT payments by 20% a year, starting with a lower payment, allowing for a much larger payment towards the back end. And you'll see as we did this for a client where year one, the payment was $157,000, and then so forth. Each year it increased by 20%. And the reason for that is to allow for growth in the early years and allow the GRAT to build up value to cause the GRAT to have significant funds at the end of the term to pass to beneficiaries. All right, so I'm going to skip through the rest of the GRAT talk and talk about a relative of the GRAT, which is the QPERT, and that's the Qualified Personal Residence Trust. It's another acronym we commonly see thrown around. And what a QPERT is kind of like a GRAT. So an example would be I fund a trust with ownership in a personal residence that I have. And the trust says I can live on the property free of rent for a term of years, whether that is 8 years, 10 years, 12 years, whatever the case may be. After that term, the assets in the QPERT pass to my spouse, my descendants, whoever I would like. Free, at that point, there would not be a gift tax. But on the front end, I would pay a gift tax, or better yet, have my exemption reduced by the actuarially determined value of the remainder. So, for example, if I happen to be 56 years old, and if I own a house worth $2.14 million, and I took 50% of the value and put that into a trust, a QPERT, and it was a 10-year QPERT, based upon actuarial tables, if that 50% interest is valued at $910,000 roughly, I will be considered to have made a gift of $581,000. And that gift would go on a gift tax return, it would be reported. But if my house grows from being worth $2.14 million to $4 million in that 10-year period, what I've done is I've pushed a significant degree of wealth out of my estate by making only a gift of about $582,000. This is a very nice tool that can be used, especially in a higher interest rate environment. It is very helpful because the value of this gift is based upon the IRS actuarial tables and the Section 7520 rate. So the higher the rate, the more valuable my retained interest is, meaning that the value of the remainder of the gift is lower than what it would be in a lower interest rate environment. So a very useful tool, and we have a chart here that we can send you on request if you send us an email with the heading QPERT chart, and we can email this to you. I know I've talked about this on a prior presentations exclusively on QPERTs because, of course, this topic itself is worthy of at least 45 minutes to an hour of discussion. But I did want to just talk about the nuts and bolts and let you know that this chart is here if you were so inclined to request a copy. A couple of things on a QPERT. You know, it's a trust that also is created by statute, so there are rules that have to be complied with. It can only be funded for a personal residence, and it can only have 2 QPERTs at any one time. Now, a fractional interest in the personal residence can be contributed, meaning that in my example earlier, that 50% interest in the residence, that's a common technique. So we would have a married couple who would divide their residence up into 50% tenants and common interests and have each of them fund QPERTs for the benefit of their descendants. The consideration with Q-perts, however, is if someone dies during the retained term of the Q-pert, then the assets of the Q-pert are included in the client's estate. So really puts the client back to where they were at the beginning. It's almost like a heads I win, tails I break even, meaning that if I set up this 10-year Q-pert that I mentioned and I die in year 7, well, the full value of the house is included in my estate. However, that would have occurred if I did not do the Q-pert from the beginning. So it's not something that that is necessarily adverse or negative if you die during the term, but you should be aware that the Q-pert does not provide estate tax savings if the person who establishes it dies during the retained term. Another thing to consider, after the retained term, the client has to pay fair market value rent to reside on the Q-pert. If they don't pay fair market value rent, then the IRS will impute the client as having a retained right in the trust and will cause the assets in the trust to be in the client's estate for federal estate tax purposes. So for clients whose Q-pert terms have ended, or if you have a client who set up a Q-pert, calendar the end of that term and let them know at the end that they have to pay fair market value rent, and if they don't do so, there's a potential for adverse estate tax consequences. So that's the Q-pert, the very fundamental aspects of a Q-pert. I'm going to skip over the SCRAT on account of time. Alan has given talks on the SCRAT itself, and I'm sure we'll do one again soon, but it is kind of a hybrid of the GRAT and the installment sale. And if you have any questions on that, or if you'd like more information, I'm happy to send you the link to our discussion on the SCRAT. All right, so the charitable remainder trust, or charitable remainder unit trust, is very common. That is called a CRUT, and a CRUT is really described as follows. I put assets into a charitable trust, and over a term of years or someone's lifetime, my spouse's lifetime, whomever, payments come out of the trust. At the end of that payment term, the assets pass to one or more charities that can be selected by the trustee at that time or designated in the trust document. The charitable remainder trust is a very nice tool for clients who have charitable aspirations, and also for clients who have appreciated assets, because the trust itself does not pay income tax. Instead, payments that go out to the non-charitable beneficiaries recognize federal income tax. Here's the example. I put $1 million of zero basis stock into a CRUT. It sells under the CRUT in the first year. Every year, I get a payment based upon a percentage of the value of the assets in the CRUT as of the prior year. Payments that come out to me based on that percentage are subject to federal income tax, but are deferred over the course of the payment term, so that there is a deferral in the income tax that would otherwise apply if I held the appreciated stock in my name and sold it while I was the owner. That is a really nice income tax planning technique. And CRUTs are something that I could spend hours talking about, because there are a number of varieties of CRUTs that can be established. One of which is called the NIM CRUT, which allows for the payment rights to be structured based upon a lesser of net income of the trust as determined under the trust principal and income statute under state law, or a fixed percentage. And those are all generally permitted under the IRS rules and regulations, so long as the CRUT meets these requirements, which is that the charitable remainder must have a 10% value based upon actuarial contributions. The annual payment of percentage payment must be at least 5% per year in a CRUT. In a CRAT, which is a charitable remainder annuity trust, that's a fixed dollar amount, but CRATs are not necessarily as common as CRUTs, but they are very useful in helping defer estate taxes and potentially income taxes as well for certain clients. I'm just going to drive us down the road of a lot of our CRUT materials here and not really mention a whole lot. other than we have a whole presentation on this that I'm happy to send you if you would like me to do so. And you can send me an email at christopher@gassmanpa.com with the heading CRUT materials, C-R-U-T materials, and we'll be sure to get you that PowerPoint and recording. And the last stop here today in our alphabet soup is the CLAT, C-L-A-T, the Charitable Lead Annuity Trust. Very similar to the CRUT, except the exact opposite. In the CLAT, the charity receives the right to get payments over a certain term of years. And then after that term of years, the assets go to a non-charitable beneficiary. This is a good tool for a client who wants to cause assets to pass to, excuse me, to charities during lifetime, or potentially use a CLAT on death, known as a testamentary CLAT, to avoid federal estate tax that might otherwise apply. One example that is commonly used in forming a CLAT is if a client would have a taxable estate, what they might say is that so long as my children have trusts for their benefit in the aggregate equaling $6 million, then the minimum amount necessary to avoid estate tax will go to a CLAT that will be structured so as to avoid all federal estate tax. This zeroed out CLAT, this testamentary zeroed out CLAT, in fact, can be a useful tool to cause a client's taxable gross estate to instead not be subject to estate tax while the client accomplishes charitable goals by providing for a regular annual payment stream to one or more charities that either can be designated in the document or that the trustees can choose to down the road when each year, in fact, they can even vary the distributions on an annual basis between one or more charities, so long as they meet that criteria of the Section 501c3 charities. Now, they are a little bit different from CRUTs. CRUTs do have this minimum 5-year annuity payment and a maximum term of 20 years. For a CLAT, you can use a life as well, which can extend the period longer than the CLAT. And there are certain self-dealing rules that apply to CLATs that don't apply to CRUTs. As I said, this area can get very complicated. The goal here today is to just illustrate to you the nuts and bolts and fundamentals of these transactions so that maybe your opinion of them is that, well, you can use them in your practice or for your clients, even though they might be complicated to some extent. You at least know what they are and how they function, and potentially maybe have a client who can benefit from one or more of these structures. Really briefly on the CLAT, one thing that's been used before, again, on one of our acronyms here, the LLC can receive assets, and the client can transfer a 99% non-voting interest to a CLAT that provides for a fixed amount or a certain percentage amount each year to selected charities. And then after the term into trust for children, this can be done on death, like I said, to avoid estate tax, or could be done during lifetime in a manner, and as I'll mention it with a little more detail, over the course of a term of years or someone's lifetime, and changeable by the trustee. The charities can be selected each year. Excuse me. So it can provide a lot of flexibility in structuring for clients who do have charitable aspirations. Well, I hope that you all have enjoyed the presentation today. I was attempting to try to give us a survey of some of these topics that are very useful and maybe introduce some of our attendees to techniques that they may not have been familiar with, to potentially see if they can benefit you or your clients in your practice, or if you have a client situation that maybe fits the mold for one of these things or could be well served by using a GRAT or a CLAT or an installment sale. Potentially this can be of interest and help for you. I hope that my role today was at least up to Alan's dummy. I know I left some of the jokes out that Alan typically employs, but I certainly appreciate your attendance and welcome you to come see us every Saturday when we give these talks, and to check out one of our future webinars. Again, please feel free to email us for anything. Christopher at Gassman, PA, if you'd like any materials or if you have any questions. Thank you very much for joining us and have a great rest of the weekend.